you about a election case you participated in, Bronovich versus DNC. You were part of a amicus brief. Your brief argued that an Arizona law 2023 banning ballot harvesting was racially discriminated and violated the Voting Rights Act. Why, in your view, can't states ban ballot harvesting?
Thank you, Ranking Member Grassley, for that question. I filed an amicus brief on behalf of two clients in the Supreme Court in that case that you mentioned. And the arguments made by my clients in support of the DNC was that the two election laws in Arizona violated Section 2 of the VRA based on a number of facts that were set forth in the Ninth Circuit opinion, finding that those laws did in fact violate Section 2 of the VRA. The Supreme Court disagreed with that position, but did in fact employ a test that looked at various facts to determine whether laws are passed either with discriminatory intent or have discriminatory results. And that Supreme Court ruling in Brnovich v. DNC set forth various guideposts that I would follow if I am so lucky to be confirmed to the court.
Okay, thank you. I want to ask about another case dealing with religious freedom. In Bryce, you filed a amicus brief. Your brief argued that Phoenix was required to force owners of an art studio to create custom wedding invitation celebrating same-sex weddings in violation of owners' sincerely held religious beliefs. You compared the situation to a hotel owner who banned a Jewish group from using a hotel pool, and to a shooting range that described itself as Muslim-free zone. In your view, is a decision to decline to print same-sex wedding invitations religious discrimination?
Thank you, Ranking Member Grassley. In that case, I represented a group of religious organizations that sought to file an amicus brief to urge the position that a facially neutral and generally applicable anti-discrimination ordinance in the city of Phoenix did not violate the Free Exercise Clause, and that a broad exception to that rule could raise concerns about the Establishment Clause. The Supreme Court of Arizona disagreed with that position, and since that case, there have been a number of cases decided by the U.S. Supreme Court on religious liberties. And if I'm so fortunate to be confirmed, I will uphold the rule of law and the precedent of the United States Supreme Court on the religious liberty and free exercise clause rulings.
Let me go to Judge Pryor. On May the 24th, 2014, you delivered a presentation to a group of students to improve their financial literacy. You identified that the students would need to provide two forms of identification, and then you had several things they could pick from to make that but you noted that, quote, a major topic was to emphasize proper identification. And of course, I agree with you on that point for opening a bank account. But my question to you is, should voters be required to show identification when they go to polls? If not, why not?
Thank you, Ranking Member Grassley. Let me start with that presentation that was made in May of 2014. We were expressing to the students the importance of financial literacy and that what you would need to open a bank account in the context of voting rights and the ID that will be required to be able to vote. As a federal judge, I must be careful not to speak as to my personal opinion. I will agree, Ranking Member Grassley, that I will continue, as I've done over my years on the bench, to be sure to follow binding precedent of the Supreme Court as well as the Seventh Circuit regarding laws applied as to the need for an ID for voters.
Okay, I'll have some additional questions for answer in writing. Thank you all both very much.
Thanks, Senator Grassley. Senator Whitehouse.
Thank you, Chairman. It's good to have you both with us. Let me ask you first, based on